You did not. Any reason why?
I didn't think it applied because I was just adding a doorway on the interior wall, so I didn't think that it affected it. But since working with Mark and Jim, I found that I was wrong. But
Did you do that in Montgomery, New York, where you
What?
currently live?
I didn't do anything like this in Montgomery, no.
No, because anyway, go ahead.
Yeah. And then once I did that, I looked for a renter for the apartment.
And you still didn't think you needed to come to the town to get permission to rent, or at least find out what you needed to do to rent it?
Actually, no, I didn't realize there was a permit application process, but since then, I've learned that.
So even safety regulations, health regulations, none of that crossed your mind?
From a code perspective, I did my homework on the code and made sure that I complied with code.
Did
for the
the
build-out.
town verify that you complied with the code?
No,
No.
I did not.
Okay, keep going. So you converted it, you rented it.
Yeah, and then since then, I found that I was not, I was in violation of the rental and not pulling the permits, and so since last year around, I forget the exact date, but maybe October-ish timeframe.
Almost a year ago. Mhm.
Yeah, I started working with the building department to start arranging for where my deficiencies were and what the appeals process was to get on record.
Okay. All right, Mr. Chairman, I'll come back later if I've got more.
Oh,
questions.
surely, yeah,
Okay.
absolutely. Any questions you want to ask at any time? Please, Mr. Igo, any questions about the petition?
I'm going to come back in just a minute.
Mr. Nicanello?
Good evening.
Evening.
So, you had a nice house. Did you ever live in that house yourself?
did not,
You
no.
did not. So you just rented that out, and then the one in the back just morphed into an apartment, and you, and then you went through your mind as far as building codes, and you had thought that you would be able to suffice your needs and rent out the other part of the property, which is the back house, right?
Yes.
And that's been going on for how long now?
I think I started renting midway through 2018, around that time frame. I could find out exactly, but
And you got notices from our facility, our building department, it looks like, and it just kept going and going, and you were traveling, whatever, you didn't feel that it was real important?
yeah, no, not that it wasn't important, but I had arranged a meeting back in October. There were some follow-up items that I needed to follow up on. There was some stuff that Mr. Grillis was looking into for me, so I was waiting to hear back, and then I received a second notice around February, I believe was the date. And then I realized, obviously I'm not going to hear back from Mr. Grillis, so I reached out to initiate a second meeting. And then I just got really busy.
And then so some fines were imposed, and then you got serious?
Well, no, it wasn't the fines that made me get serious. I
Okay.
wanted to drive this to a conclusion, and it's just a matter of, just timing, really. I'm guilty of that for sure.
I mean, there's people all over our town would love to do what you're doing, but, we have to follow the guidelines because at town meeting, the people set the rules in the town, and we're just here to enforce it. So, to me, it starts off as a bad egg, you know what I mean? I would love to be in the rental business myself, but I don't do that.
Yep.
I have to comply with no matter what town, out of the 351 towns in the Commonwealth, it's up to me as a homeowner to make sure I follow the rules of which each town I live in. I don't know if it's different outside the country or whatever, but, in our Commonwealth, we have to abide by the rules, so. That's it for right now, Mr. Chairman, thank you.
And how about you down there, Mr. Barron? Any questions of our petitioner?
Yes. We have quite a body of correspondence.
We're gonna, it's mostly concerning Mr. Brandolini and Mr. Mark Grillis, so I'm gonna let Mr. Brandolini speak to most of that correspondence.
Yes, but-
Instead of reading it all,
But,
okay?
yes, I'm not going to read it, but my question is is directed to the fact that in all of this correspondence, there's been no indication that you intended to occupy either structure on the property as a primary residence. Am I correct in that assumption?
Right now, that is correct, yes.
Do you intend to in the future?
Yeah, when I retire, this is part of a retirement plan.
You look fairly young. How many years in a?
About 8 years is my plan, assuming things go according to plan, yeah.
That's all I have at this time, Mr. Chairman.
Well, you know, I'm familiar with your property. I don't live far from you, and, you know, you keep it very nice, and I appreciate that, whether you're here or you don't. One of the purposes behind the town meeting determination that these properties had to be owner-occupied has nothing to do with you as an individual who might be very responsible, but it does have to do with the general rule of thumb that an owner who's in occupancy will make sure the property stays looking good, whereas tenants, I've had tenants in standalone homes, and for some reason, I've always ended up paying more in, you know, for damages beyond the escrow than the rent was worth in my pocket. So it was a losing proposition in each one, because the tenants left to their own devices would destroy my property and not think two bits about it until they came over to inspect it.
Right.
And so that's one of the reasons, particularly in a small community like ours that's almost all residential, that we have this rule that's, as long as I have been on this board, enforced. And I know of one circumstance that predated me. It didn't predate the gentleman to my left, but it predated me. And it's right down here on Route 28, and you can see it where claimed to be that person claimed to be owner-occupied, and it's probably one of the second worst eyesores on 28, even though it's still existing and standing out. So that's why we get very concerned about these this rule. That's my belief as to how 407 came into play, and particularly what you're asking relief from, which is 40729 is the biggest thing that I think you have here. Mr. Brandolini, I have no other questions of you other than I do want to say to you, I appreciate the fact that you're probably a very very responsible homeowner and businessman as you deal with your tenants, but we also aren't in the business of creating duplexes in this town, and that's essentially what we'd be creating here. So,
Mr. Chairman, can I just ask one follow-up question? Has the unit been occupied the entire time that this correspondence has been going back and forth between you and?
It is.
There's been people in there the entire time?
Yes.
And you never thought that that was a concern, that maybe you should vacate the property while the details get worked out?
I didn't expect it to go this long, and this was not the intent
Well,
of working with.
right, but there were
with the appeals
several
process.
missed deadlines anyway, there were several missed deadlines that were your responsibility to meet, and you didn't meet them.
During my correspondences, there were no set deadlines. We had a conversation, and we had follow-up items, and I was producing those follow-up items. I felt like I was being responsive, but, you know, it just took time. I mean, I'm not disputing the fact of the time it took. It definitely took longer than I anticipated.
And you collected rent the entire time this was being adjudicated? Okay.
I do have a question. Did you know your predecessor or owner, or was it just?
I did not,
an arm's
no.
length?
Just from,
Was there a tenant in there when you bought it?
not that I'm aware of. I don't know.
So, well, you probably inspected it when you bought it. Did you see any tenant in the garage?
It was furnished.
Huh?
It was furnished when I bought the property, but
Did you have legal counsel when you bought it?
I did not.
Because legal counsel usually checks to make sure that the special permit has been granted. At least here on the Cape, it's a Cape Wide, it's a pretty common thing that we expect the owner to occupy these properties.
Right.
So, you know, that's why it's always good, I guess, to have legal counsel. Not that I'm trying to drum up legal business for anybody. I don't do that sort of work. But Mr. Brandolini, what do you have to tell us this
Hi,
evening?
good evening. First of all, I sent the board and Mr. Lebrandi a memo regarding, there are two variance requests, and one of which does not apply. I sent the board that memo yesterday and a copy to Mr. Lebrandi. The second variance request relates to section 407.2.1, paragraph 2. That's not germane, that's not germane to the family-related apartment. I'm sorry, it's not related to the affordable unit. It's germane only to family-related units. So I suggested that Mr. Lebrandi withdraw that request.
Okay. Duly noted.
In terms of some of the history, on October the 23rd, 2018, a violation notice was sent out by Building Commissioner Mark Grills. As a follow-up to that, I had sent out a violation notice June 6, 2019, and noted that failure to comply would result in tickets being issued. There were various emails sent back and forth between myself, Commissioner Grills, and Mr. Lebrandi in the meantime. And on August 6th, I issued there was a third violation notice along with associated tickets. Mr. Lebrandi and I had a phone discussion, and I said to Mr. Lebrandi that I would put the tickets in abeyance providing he either complied with the order to cease and desist or apply to this board for variance. But the tickets are only in abeyance. I have not voided them. So here we are today with the request for the variance. I had hoped that this had been addressed sooner, but unfortunately had not been.
Okay, Jim, perhaps people on the board might have questions of you. Mr. Barron, any questions of Mr. Brandolini?
Mr. Brandolini, is, other than the fact that the regulations have not been complied with in a timely way, do you see any issues with either structure, either the principal structure on the property or the second one to the rear of the property?
I've only been able to access the unit in question.
The second one?
Yes, the converted garage. And there were some building code related issues and some electrical issues that we observed that would need to be addressed. And
Doable items?
yes, Yes.
Reasonably doable?
yes.
Okay.
For the
Just-
record, those items have been addressed since our inspection visit.
All right, thank you.
Thank you. Mr. Brandolini, good evening, and thanks for coming this evening.
Thank you.
In your many years of experience, when you send out some notices like that, what's the typical response from the people you're sending the notice to?
I would say 60% of people respond
Right.
within a reasonable time,
Okay.
60 to 65%.
That's all I have right now. Thank you, sir.
I have a couple. I see that there's a history of having a prior relief sought for this property, not by this gentleman, by a prior owner. Did you go back and find that history, did you?
I did not.
Well, my understanding is, based upon
Excuse me.
This is the notice of violation on October 23 of 2018. And I'm assuming that's what you mean by there's been a long delay.
Yes.
Yeah.
Yes.
Because it's October and now we're almost into it.
That's correct.
A whole year. But begging that off just for a minute, Mr. Grillis indicates here on page 1, a previous owner had applied for the required building permit in 2016 to construct a dormer on the existing garage. The health department at the time considered the extra room a bedroom and affirmed it to be a 3-bedroom system, which was installed, I guess is what he meant here. That was in the accessory building, right? That's what we're referring to?
That's correct. That's correct.
And they considered it to have a bedroom at that time in the accessory building?
Well, just to share my knowledge of that, the garage was constructed in about 2002, and on the floor plan of that proposed garage, it depicted within the garage a proposed workshop and a future bathroom on the first floor.
Yes, I think we sat on that, didn't we? Did that sound familiar to you and I?
Maybe.
I don't
Didn't
think that
require relief?
triggered relief at that time.
Okay, I'm thinking of something else.
Yes.
I apologize.
So a building permit was issued to construct the garage on that basis. A couple of years later, as I recollect, the former owner applied for a building permit to construct a dormer and a rear set of exterior stairs. No floor plan was submitted as to the proposed use of the second floor or the first floor. The permit was issued solely to construct, to construct the dormer and the second floor exterior stairs. Never have there been any permits issued to create rooms or to allow the use that we have today.
I'm just interested in
Yes.
this reference to the health
It's-
department having considered it 3 bedrooms now,
They,
and that
Wh-
being
when
an
the-
addition of a
yeah,
bedroom.
when the permit application was proposing the dormer, for the health department views a room, and whether it's labeled a bedroom or not labeled a bedroom, they view it as a bedroom.
No, I understand
And-
that, but I'm wondering if at the time there was any discussion about plumbing in that, or any
None.
room petitions or
Yeah.
anything else, to the best you know.
None that I recollect or that I see in the file.
But there is now plumbing in the structure.
Yes,
And that plumbing was done without the benefit of a permit.
that's my understanding.
And there is electric that's done in the structure without the benefit of a permit.
That's my understanding.
Okay. And again, I'm not faulting necessarily our petitioner here, but
Mm-hmm. Yes.
somebody did that without the benefit
Yes.
of a permit. And again, one of the good reasons why we always should at least look at the field card before we buy properties to make sure what we're seeing on the ground is actually permitted
Right.
by
Yes.
reference to the field
Yes.
card, you know.
So just in response to that, I did look at the field card
Yeah.
at the time that I purchased the property, and it was listed as having a bedroom and bathroom in that back apartment.
It was.
It
Yeah.
it did.
Yeah, well, I've got the field card here, so let's see.
I'm looking in the building permit record, I don't see anything. This field, this is the building we're talking about, right?
It is.
I'm looking on the back of this field card, and I see building permit record, and it has none.
Well, building permit record, addition, accessory structure, deck, and then residential, 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 residential.
That's on this one, though.
I'm looking under,
It's in the house.
Oh, okay.
I was referring to the construction detail section of the rate card, where it
I apologize,
itemizes
you're
the total bedrooms, total bathrooms.
But I don't know, maybe they marry these two together.
Well, you know, it's funny, how is it being taxed? It's being taxed as a single family. One bedroom. It's being taxed as a one bedroom. I don't see anything about a bath or anything else. And this is, again, the reason why we're concerned about permits in this town, and every town, because, and particularly here in Massachusetts, most of our revenue for towns is generated off of real estate taxes. And real estate taxes are determined by the value of the home, and you know, a structure that's livable is worth a lot more than a structure that contains one open room above a garage
Right.
workshop. And so that's why we get concerned about these things. And again, the fault is, I'm not suggesting any fault lies on you relative to the construction of this addition, but, you know, this completion of that second floor. But I am suggesting it's certainly not in compliance with our law. And the relief that you're seeking, in my opinion, is, I will tell you, I'm not going to support it. I don't even need to read the correspondence into the record. I'm not going to support it because I don't believe any structure should not have an owner in occupancy if there are two living accommodations on it, unless it has been a property that has been condominiumized. Then, you know, each structure can have an owner live there or not.
That would have
It
to
out.
be, that would have to be a legally pre-existing unit, correct?
Yeah, that's right. No, you'd have to start with a
Yes,
unit
so-
that's actually existing.
So is it fair to say we don't even have a legal unit here because there was never any building permit?
That's correct. That's correct.
So,
Well, the correspondences we had previously were, once the appeals process was over, if there was reason for me to continue that process, I would backdate whatever permits that were required.
yeah, I'm
You know-
speaking, I think, a little bit broader that, I mean, I'm only one of 5 members here. But you need to have at least a 4-to-1 vote in order to get the relief you're looking for.
Right.
And there's no way I'm going to support any petition before this board to create 2 units of living accommodations where the owner is not in occupancy on one lot, on one house lot. I cannot, in good conscience, do that for you or for anybody, so.
Can I just chime in here, since we're on this subject here? The relief you're seeking here under 407, is that a misprint P10? Because 2025 P10, I've got municipal use for wind turbines. Is that just a misprint?
That should be an R10.
R10,
R10.
okay, all right.
Accessory apartment,
I
yes.
got P10. Okay.
Yeah, we're not talking
All
wind,
right,
please,
well,
no wind turbines.
We won't be going there, but in terms of the 407 bylaw, you've got to comply with 2 and 9, and you're not. I mean, we can't grant you a special permit unless you comply with all of these requirements. So we can't grant you a special permit. In terms of variance relief, I mean, you could make a pitch to us if you think you can meet the requirements under a variance, but I don't see you meeting the requirements under a variance.
The requirements for,
A variance?
no. The requirements for the variance, I believe, I do make. I mean, I can run through what I believe is my case of
Well,
that.
Sure, we can have you do that.
We can have you do that. In terms of what the chairman has said, though, I've looked at this myself. I've seen what you're looking for.
Yeah.
This is not a petition that I could support either.
Okay.
So I'm certainly willing to listen to your request for variance relief if you think you may meet the standards for a variance.
Right.
And I would consider that. I certainly don't think you meet the standard for a special permit.
Okay.
And may I ask, are both units now occupied
They are.
by tenants?
They are.
Unrelated family members, right?
Correct.
One family in the garage, one family in the house. Okay. I mean, I can't even find a way to stretch that, to think about it, you know, but, okay, but that's just my feeling. Britta?
Mr. Igo, if I may, I had said R10 and I was relating to the residential use table. It's actually A10
A10.
A10.
Oh, A10, okay.
in the residential use table.
All right, and that's fine. I thought that was just a typo. That's all right. Thank you.
Ms. Britta, did you have
For
anything?
building code purposes, it's identified as R.
I'd ask Mr. Brandolini, our petitioner is going to suggest the criteria that might be met on a variance, which, as we all know, is a whole separate bit of relief. And so if you would just hang in just for a moment
Sure.
instead of running back
Sure.
to Mashpee, please go right ahead.
So just, I mean, before I do that, because, I mean, it seems like I'm already two against already. So it doesn't seem like that's very fruitful. I'd like to just address the concerns on the owner occupation, which is the variance I was seeking. If, you know, I understand the reason for the owner occupation requirement. I mean, I do believe in that strongly. I do inspect the property quite frequently to make sure that, you know, the tenants are keeping up the property and the structures. So, you know, from a responsibility standpoint, from a, you know, impact to the neighborhood standpoint, you know, I take that very seriously. So I know it doesn't do anything for you, you know, legally, but that is my own, you know, my own personality. I don't want to have an eyesore. You know, that's
That's why
not
I
what-
started my comments the way I did, because your property is a nice property, it's well-kept, and there's no doubt in my mind that you are probably a wonderful owner and a wonderful landlord. But we have a town meeting that's, and I think Mr. Nicanello spelled it so well. I bet there's not a person on this board that wouldn't like to try to give you some relief because you seem like a nice guy and you're gonna do a nice job over there with your tenants. But we only enforce what the town meeting tells us we can enforce. And we can't get over this 407.2.9. It's not that that's something that's subject to variance or special permit. That can't be altered. Those are requirements.
Okay.
And then the ability to have an accessory apartment, whether it be an affordable apartment or it be a family-owned, a family-related apartment, is what requires the special permit, or as you're suggesting, variance perhaps. But the requirements, we can't change.
Right.
We wish we could in some instances, and yours one of the instances, personally, I wish I could. But I also know that I probably wouldn't, even if I could, because I don't want to go down that slippery slope.
Right.
So if you had anything specifically, do you understand what variance requirements are here?
As far as the three things, right? The substantial hardship due to local circumstances, and detriment to public good, right? Those
Yes,
those
yeah.
ones. Yeah, I'm aware of those.
Owing to conditions related to the soil topography or shape of the lot?
Yes.
Okay.
You know, and sometimes we, so you know, we as a board look at those other words in two, and especially such land or structures as being a viable argument in certain circumstances, and not this type of circumstances.
Right.
But sometimes we go a little further in our thought process based upon that. But in this instance, because the structure wasn't even done by permit, that is not a justiciable argument under two of the requirements of a 102.2.2.
But this. It sounds like they didn't. Okay.
Then when we go to 3, desirable relief can be granted without either substantial detriment to the public good or nullifying or substantially derogating from the intent and purpose of the bylaw. The intent and purpose of 407, which we are required to enforce, whether we like it or not, is very clear. The town meeting has spoken, our governing body, the town meeting,
Right.
has set forth very specific requirements. So, is there anything else you wanted to say towards either the request for special permit or variance? Because I'm not going to read all this lengthy email exchanges in here.
No.
With what I believe the ultimate outcome is going to be.
Mr. Chairman, may I ask one more question?
Yes.
The gentleman that's sitting next to you, is he the occupant of the building?
No.
Okay, all right.
You're welcome to chime in with anything you'd like to say. I mean, we want to hear everybody that's interested, so.
Neither building that you have, neither building you has a resident who is related to you.
That's correct.
Correct. Okay, That's all I wanted to clarify.
I just think that
State your name, please.
Simon Milberg,
Thank you.
Thank you, sir.
I remember seeing the plan when he bought the house for the garage. I know he didn't throw it out.
No, we
I'm sure
haven't.
he still has
No,
it.
the plan is here.
And the lady that owned it
She had an apartment in there?
was older. Well, she had her grandkids in there.
Oh.
She didn't do anything, I'm sure, she didn't do anything without getting permission. Now,
I can't speak to it. I
no,
can
I
look at
can't
it.
either, but that's why I say, I think we have some plans that she had okayed by the town. Don't you remember that?
Yes. Actually, it says it right here on the card.
I like this.
I know. No, but that doesn't, that's just a plan from an engineer. This is what would be the record.
If I may, Mr. Chairman. So the field card where you said the detail, construction detail, it still says it's only one bedroom, and that was because the Board of Health had said that. So the Assessor's Department had never got any update to reflect what happened in that structure to what is on this card.
They didn't?
No, because if you look at it, it says total bathrooms, 0. Okay? The bedroom was allowed because of what the Board of Health had saw when the septic was probably connected, a total of 3 bedrooms.
May I approach?
Sure, you may approach.
Just curious about the 0, because I'm not seeing that online. So I just
Sure, that's fine.
wanted to see what
I want you both to speak into the microphone, though, as you
As you can see where it says 1 bedroom, right underneath says bathrooms.
Yeah, bathroom's 1.
Bathrooms 1.
Is that?
Oh, I'm
or no,
sorry.
am I reading that?
Oh,
wrong?
yeah, half bath 0, I'm sorry, yeah. okay.
That's what I was reading
Yeah.
and
Okay.
why I thought.
Yeah. Okay, no, my apologies.
Yeah.
So there was
So
a
somewhere along the line, the assessors got some information, but as far as what the woman had done with some plans and okayed by the town, it should have been reflected right on here.
That's fine, but I just want to say
Yeah.
that we didn't do anything. There was a kitchen there,
No, I understand.
Oh, of course.
Right.
and a
That's-
bedroom.
Oh, of course,
That-
nobody's faulting you.
That-
But
that's-
look at it, there's an awful lot of illegal structures all over the
I
world.
understand.
And that doesn't, the fact they exist doesn't change the fact that they're illegal.
I understand.
You know, and so, in this instance, it may exist, it may be built to code, it may be an attractive apartment. We don't know if it's built to code because it hasn't been inspected by the building department. And we also know that it has never been illegal. It was not a pre-existing non-conforming structure. By pre-existing, we mean to when we adopted zoning here in this town. Because we know that because the dormer only came into existence in 2006.
Yes.
Long after zoning. So, again, it's a question of, irrespective how we may feel about you as an individual, and I don't see any fault with you as an individual, and it took almost a year to get here, but irrespective of that, we can't do the relief under either guise. The only way we could do it is under a variance, and I'm not hearing the variance at all. So, you can ask us to take a vote on this evening. And a vote on this would mean that you could not return seeking a similar relief on this for how long?
2 years.
2 years.
Okay.
You could ask to be allowed to withdraw both the special permit and variance relief that you are seeking. And usually without prejudice to you, in case you at some point wanted to come in with some other thought process on this. And we would generally allow that sort of thing. Other board members may feel differently because of how long the violations have been in existence, the violation notice have been in existence. And how much of the fines are racked up to now?
$700.
Have they been paid?
No, because as I mentioned earlier, Mr. Chairman, I had agreed with the petitioner to put those in abeyance, subject to either compliance through cease and desist,
Or get a decision?
or get a decision from the board.
All right. And assuming there was a time frame when one of those buildings would no longer be occupied, what's your feeling on the violation fines that are here so far?
With respect to the fines?
Yeah.
Well, under two circumstances, should the board deny the petition request, or should the petitioner withdraw without prejudice, there need to be some understanding, or there would need to be a firm understanding, that the use would have to cease because of the life safety situation. I mean, frankly, anyone who occupies or allows to occupy, allows the occupancy of a building without certificates of occupancy, without a certificate of occupancy and inspections and permits, runs an extremely high liability.
I think it runs liability on our town when we
It does, yes.
seek to enforce it.
Absolutely, absolutely. And that's why, from an enforcement standpoint, we could not allow the continued use as it is today.
So, I'm going to defer to you. If you'd like us to consider, sometimes we consider, I can't speak for board members this evening, I can speak only for myself. I would certainly vote to allow you to withdraw without prejudice, because the fines are there, you'll have to deal with the building department on that, and they're not going away apparently, so. And, maybe good faith in getting these people out of there real quick would abate some of it. You're certainly welcome to rent your home, is our point. That's a given, but everybody can rent their own home.
One home.
Just,
One
One
home.
home.
just,
That's right. One home, one occupant.
Mr. Chairman, just as a footnote to that, I've been advised by the Board of Health Housing Inspector that there is no rental certificate for the
So
house.
you have to get the required rental certificate, which is an inspection, and they come in and just make sure that you're up to sanitary code.
Right, right.
So you could do that. In any event, it seems like there's a lot of violations. But we'll move on. Do you have any thoughts as to how you'd like us?
I just had one question, just on the variance requirements. What specifically was the concern out of the three, or all of them, or, I just wanted to understand the details before I make my decision.
My concerns
Yeah,
are, irrespective of whether or not this involves a financial hardship to you, that there is nothing about that hardship which is related in any way to soil conditions, shape, or topography of the land or structures, and especially affecting those structures or land, different in kind than that generally within the zoning district.
okay, so that's the one specific one.
No, and secondly, I don't believe desirable relief can be granted without derogating substantially from the intent of the bylaws as they currently exist by a town meeting vote.
Okay.
And thirdly, if you only have two, I don't think you meet the third criteria for a hardship either. First of all, because the hardship was self-imposed. You present yourself here today with an illegal structure. So you can't say to this board that you're suffering a financial hardship for something that you're trying to do that's illegal.
So,
Yeah. I'm not going to argue that. I don't agree with that comment, but I'm not going to push it.
well, that's okay, but all three may need to be.
The other one doesn't make it anyway, so. Yeah.
Differing minds can have differing thought process on
Yep.
How would you like us to proceed at this point?
I think I'm going to go ahead and withdraw without prejudice, but
You'd like to, well,
But
you
when-
can ask for that.
okay. When I do that, though, I mean, as far as, am I committing to fines and stuff like that at that point, or is that sort of a separate item, or?
I'm not going to speak for the enforcement arm of the fines. Those fines continue on and are never abated merely because somebody has sought relief. Mr. Brandolini has generally, as has the building inspector's office, generally been very understanding that if relief is sought, they will be held in abeyance for enforcement.
Right.
The forgiveness of fines is generally something that I don't think he can even do. I know this board can't. Sometimes what we will consider is to ask the building department to waive those sorts of fines or consider reducing them if we're getting another desired relief that's good for the town. But that's not happening here, so that's between you and him. We don't get to control any part of that, okay?
Right.
We don't.
And with my intent, I'm sorry, Jim, you're going to say something?
The building department would need to know what Mr. Labrandi's intentions are in terms of compliance.
There's two illegal rentals going on there.
Yes.
Irrespective of whether or not there's relief here, those rentals of each property are still illegal because there's no rental certificate.
Yes, that's correct.
Okay, so which would you like us to do?
I'd like to apply for withdrawal without prejudice.
Okay, so there is a request by the petitioner that would involve 2 votes by the board, okay? There is a request by the petitioner to be allowed to withdraw the petition for the grant of a special permit without prejudice. Does the board care to have any discussion on that request before moving it along to a vote?
Well, you need a motion.
I know.
Yeah.
I know, sure.
I'll move that we allow the petitioner to withdraw his request for special permit without prejudice.
All right.
Second.
Who seconded?
Mr. Barron?
Now, anybody want to have any discussion?
No.
All those in favor of that motion to allow the withdrawal of this matter, of the special permit petition without prejudice, please indicate by saying aye.
Aye.
Those opposed? That carries unanimously. My hearing, I'm getting old, I apologize.
I'd like to make another motion to allow
Yes.
the petitioner to withdraw his request for variance relief.
Mr. Igo makes that, Mr. Barron seconded.
Yep.
All those in favor of that motion, please indicate by saying aye. Aye. Those opposed? That carries unanimously. I do hope you have good luck. We'd always welcome it, if you wanted to become the owner and occupier, that you to come back and get either an accessory or a family-related apartment.
Yeah, in 8 years.
Huh?
I said, yeah, in 8 years.
Thank you very much.
Thank you.
With that, we'll move to adjourn the meeting, and we so adjourn. Thank you.
Thank you.
Somebody's gonna, sometimes it's enforcement action, all the time.
It's so long since I've seen you. How you been?